Hello and welcome to the analysis of the Hindu newspaper dated November 1st, 2022. In this video, we are going to discuss two important newspaper articles which are important from the Hindu newspaper. Now, it doesn't discard the fact that other articles were not present which are very important. There were other articles as well, and that is why we have put a list of important newspaper articles. Now, these articles do not require that kind of explanation which the two other articles which we are going to discuss require, and that is why we are going to discuss just two important newspaper articles. So if this is very clear to you, please do consider subscribing to this channel to never miss an update from the bureaucratic way, and join us on Telegram to get all the important PDFs important for the civil services examination. Now with this, let's now head to the first important newspaper article. Now this particular newspaper article is regarding a Supreme Court judgments. As you already know, the Supreme Court judgments are very important, very significant, because they can be directly used in the answers of the mains examination. And that is why we are going to discuss this particular newspaper article, which is regarding a two-finger test. Alright. So now the Supreme Court on Monday declared that any person conducting the invasive two-finger or three-finger vaginal test on rape or sexual assault survivors will be found guilty of misconduct. So earlier, according to the guidelines of the central government, what happened is that a two-finger test was or three-finger vaginal test was conducted on the rape or sexual assault survivor. Now this particular test was used in order to figure out whether the person went through a rape or sexual assault. Now the Supreme Court is saying that this particular test will not be conducted anymore, and whoever conducts that, medical examiner who conducts this particular test, will be found guilty of misconduct. Now let's discuss what in detail what was written in this particular judgment, or what was the judgment given by the Supreme Court. Now in a judgment, a bench led by Justice Chandrachud said the sole reason behind using regressive test on traumatized sexual assault survivors is to see whether the woman or girl was habituated to sexual intercourse. Now the bench led by our Justice D.Y. Chandrachud said that this particular test was only done in order to identify whether the particular woman or girl was habituated to sexual intercourse. Now it is very unscientific because it doesn't determine this particular sexual that habituation of sexual intercourse doesn't define whether a person it doesn't concern whether she was raped or not, right? Such a concern such as habituation to the sexual intercourse is irrelevant to the fact whether she was raped or not, and previous sexual experience is immaterial to the question of conduct, says the Supreme Court. Now the Supreme Court goes on further to say that the two-finger test is a faulty logic because it takes a logic that a woman cannot be believed when she said she was raped merely for the reason that she was sexually active. If a woman is sexually active, it doesn't mean that a man is allowed to have a sexual intercourse forcefully on her. Now the logic which is used by many of the people that if a woman is sexually active then you can force yourself upon them is very faulty. Now this so-called test has no scientific basis and neither proves or disapproves allegations of rape. For example, if a sexual worker goes through a case of rape, then this particular test is very faulty, right? And it instead, this particular test, that is the two-finger test, instead re-victimizes and re-traumatizes women who may have sexually assaulted, may have been sexually assaulted, and is an affront to their dignity. Alright, so now the two-finger test on pre-vaginum test must not be conducted, says this particular bench, which also comprises of a woman justice, that is the Justice Hema Kohli. Alright. So now the previous judgments or acts were also taken into account in this particular judgment, because it usually happens that the previous judgments are looked upon, the acts already existing are looked upon to take into the to take a decision, to arrive at a decision. Now the court pointed out the 2013 amendment of the section 53A in the Indian Evidence Act. Now this particular section 53A of the Indian Evidence Act says that the evidence of a victim's character or her previous sexual experience with any person shall not be relevant to the issue of consent or the quality of consent in the prosecution of sexual offences. If a person's that the victim's character, whether the victim had went through other earlier sexual experiences, it doesn't determine the fact that a other person is allowed to force upon that particular woman, and at the same time this doesn't mean that she is providing consent. She may have the sexual experiences earlier as well, and it doesn't determine the fact that you are allowed to do that particular act, do the rape, right? This is what is being taken into account in the Indian Evidence Act. It doesn't determine it. There is no evidence of it, right? The evidence of a victim's character does not hold that you are allowed to do that, right? Now the court also gave the further directions to the Ministry of Health and Family Welfare. Why? So the bench noted that the Ministry of Health and Family Welfare had issued guidelines for the health providers in the case of health sexual violence. Now in these guidelines, the Ministry of Health and Family Welfare have prescribed the application of two-finger test. Now this particular two-finger test is no longer, or it will now amount to misconduct, and that is why the court has asked to remove the application of the two-finger test in its guidelines, right? So the court directed the center and the state governments to ensure that the ministry's guidelines were followed to the letter, and the court ordered that the guidelines be circulated to private and government hospitals that no longer two-finger test is going to be conducted. Alright. So the judgment has been passed by the Supreme Court, but now it is the work of the executive, that is the government, to execute this particular judgment. So this is it regarding this particular Supreme Court judgment. Let's now head to the next important newspaper article. Now this particular newspaper article is regarding the amendments to the IT rules 2021. Alright, so now the IT rules were formed in 2021, but some of the amendments have been made to these IT rules. Let's now discuss what is written in this particular newspaper article. So the Ministry of Electronics and IT, that is METI, has notified amendments to the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, that is IT Rules 2021, on October 28th. Alright, so now in June 2022, METI had put out a draft of the amendments and solicited feedback from the relevant stakeholders, and after it the amendments have been made. Alright, so in June 2022, this particular draft of amendments was put forward and now these particular rules have been implemented, or these have been notified. Amendments have been notified now. Alright, so now what are the IT rules 2021? So these particular IT rules are for regulating the social media intermediaries in plain simple language. Now what are the problems with the SMIs? But that is the social media intermediaries like Twitter, like YouTube. Alright, so all of these are the social media intermediaries. Now the first problem with the social media intermediaries is the centrality of the SMIs in shaping public discourse. They can form opinions, they can shift the biases of people, right? Now the second problem is the impact of their governance on the right to freedom of speech and expression, because certain tweets or certain posts can be removed by these intermediaries, or they can be shaped, or they can decide which thing is going to get viral, and that is why the right to freedom of speech and expression is also impacted by this particular social media intermediaries. And apart from it, the third problem is the magnitude of information they host, and the fourth problem is the constant technological innovations that impact their governance. And that is why the IT rules 2021 are formed. So in a bid to keep up with these issues, India in 2021 replaced its decade-old regulations on the SMIs with the IT rules 2021 that were primarily aimed at the placing obligations on the SMIs to ensure an open, safe and trusted internet, right? So what is the need to amend the IT rules 2021? So the objectives of the amendments were threefold. So the objectives were, there were three objectives. First one is there was a need to ensure that the interest and constitutional rights of the netizens are not being contravened by the big tech platforms. Alright, this is the first objective. Second objective is to strengthen the grievance redressal framework in the rules. And the third one is that compliance with these should not impact early stage Indian startups. The Indian startups or early stage Indian startups should not get affected by all of these compliances. Alright, so now what are the proposed amendments? So the proposed amendments are of two categories. First one is the additional obligations on the SMIs, which is done to ensure the better protection of the user's interest. And the second one is the institution of an appellate mechanism for grievance redressal. That is the formation of a grievance redressal mechanism. Alright, so now we will discuss these two categories. Let's first discuss the first category, that is the additional obligations which are put on the SMIs. So there are four obligations or four additional obligations which have been placed on the SMIs. So the first obligation is that they need to ensure the compliance with the relevant rules of the platform. So earlier it happened that or in the original IT rules 2021, in the IT rules were formed in 2021. Now these obligated that the users need to be informed regarding the privacy policy and the user agreement, but now it has been extended to ensuring that its users are in compliance with the relevant rules of the platform. And further, SMIs are required to make reasonable efforts to prevent prohibited content being hosted on its platform by the users. For example, the pornographic content, it will not be there on their platforms. It needs to be ensured by the SMIs. Alright. So now the second obligation or a second additional obligation is to respect all rights accorded to the citizens under the constitution, that including in the articles 14, 19 and 21. Right. Now you're operating, these social media intermediaries are foreign. If they are foreign in nature, they are operating in the Indian soil, and if there is any kind of violation of these articles, then it needs to be taken account. It needs to be taken account the fact that these articles, that is article 14, 19 and 21 are followed. And apart from it, the third obligation is the SMIs are now obligated to remove information or a communication link in relation to 6 prohibited categories of content as and when a complaint arises. If the complaint from the government arises regarding the 6 prohibited categories, or if the complaint is from the individuals as well, if they lie between, or this kind of content lies in the 6 prohibited categories which are made by the government, then they need to ensure that their particular complaint is addressed. Alright, so now they have to remove such information within 72 hours of the complaint being made. Alright, if it falls under the 6 prohibited categories, then this particular information needs to be removed within 72 hours of the complaint being made. And now the fourth additional obligation have been to take all reasonable measures to ensure accessibility of its services to users, along with reasonable expectations of due diligence, privacy and transparency. Alright, so these are the four additional obligations of the SMIs. Let's now talk about what is grievance appellate committee. Now, prior to the IT rules 2021, what happened is that the platforms followed their own mechanisms and timelines for resolving user complaints. There was no any kind of obligation from the government. The only obligation or the only mandate was that there needs to be a grievance officer who would acknowledge the receipt of a complaint within 24 hours and dispose it within the 15 days. But the rules were not that very clear. All right. So now, with the coming up of the IT rules 2021, the central government shall establish one or more grievance appellate committees within 3 months. Now, each GAC will consist of, this particular GAC is going to be formed by the central government, right? Now, it will consist of 3 members. That is, first was going to be a chairman, and there are going to be 2 whole-time members, and now they are going to be appointed by the central government, right? And of these, one shall be the ex officio, while the others 2 shall be independent members. Now the GAC will hear appeals by the social media users against the decisions of grievance officers appointed by the intermediary, and the idea behind setting up the committees is to give users of the social media platform, including Facebook and Twitter, recourse other than the reproaching the courts to settle complaints. So earlier it happened is that you went to the courts directly, there was no grievance appellate committee. Now with the setting up of the grievance appellate committee, you can directly go to the grievance appellate committee, and you can be rest assured that they will be, or your complaints will be heard in the time bound manner, right? Now what are the limitations of this particular amendments of the IT rules 2021? All right, so what are the limitations? First one is the excessive government control. Now the rules may be going beyond the powers delegated under the act in certain cases, now such as where they provide for the regulation of a significant social media intermediaries and online publishers and require certain intermediaries to identify the first originator of the information. All right, if you are going to identify the first originator of the information, then what happens? Some kind of privacy is violated, right? So this is the first limitation, that is the excessive government control. All right, and the second one is the restrictive, can act on effective tool to curb the government criticism and dissent. All right, so now the government can use this particular, we are not saying that government will do that, but it can happen, right? Government so the government criticism and dissent can be now brought down, and which can be grounds for restricting online content are overboard, and the grounds for restricting online content are overbroad and may affect freedom of speech. So freedom of speech can be affected by this particular amendments to the IIT rules. Now the third one is absence of the procedural safeguards. Now there are no procedural safeguards for the request by the law enforcement agencies for information under the possession of the intermediaries, and that is the main limitation of this particular IIT rules or amendments to the IIT rules. So all right, so these are just facts. Do not take into them take them in a very light mode. Don't take them in a very hard way, right? So these are the 3 limitations of the IT rules 2021, and we believe that these IT rules are very fine. They are made by the people who are more experienced than us, and that is why we have discussed this particular newspaper article, right? So this is it regarding this particular newspaper article, and this is it for the day. Thank you from my side. Do like and share the video and subscribe to this channel. Have a good day. Bye.